Now come to order. For those that haven't pressed their button to state their attendance, please do so on the electronic voting device. Clerk will close the roll. You need to do yours. Oh, I didn't vote. I'm here. Just don't do what I say. Okay. So clerk close the roll. So we have a quorum. Okay, so a couple of procedure things that we need to take care of. The first will be striking of a bill by the patron's request. This is a recorded vote. House Bill 1584, the request of Delegate Ballard. Can I get a motion?
So moved.
Motion properly second. All in favor say, oh, well, this is a recorded vote. So please vote on the electronic voting device. Clerk will close the roll. Bill is stricken from the docket, 22-0. Okay, the next are by voice vote. We'll do these two to public safety. We'll do these in a block. House Bill 1977, patroned by Delegate Hernandez, and House Bill 2188, patroned by Delegate Freitas. This is a voice vote. Can I get a motion to refer those to Public Safety Committee?
Move to refer those to the mighty Public Safety Committee.
Mighty, powerful. Motion properly second. All in favor say aye.
Aye.
Opposed? Okay, those bills are referred. Final administrative action is House Bill 1586 to Appropriations Committee, Delegate Ware's committee. Can I get a motion?
Move to refer to Appropriations.
Second.
Motion properly second. All in favor say aye.
Aye.
Opposed? Okay, that bill is referred to the Appropriations Committee. Okay, so then let's turn to the subcommittee docket. We'll start with the Criminal Subcommittee, and that I'll turn over to Delegate Chair Watts.
Thank you, Mr. Chairman. I'd like to first move all of the amendments and substitutes as a block for those that are in the uncontested block, and I so move.
Got a motion?
Second.
Motion properly second. All in favor say aye.
Aye.
Opposed? Okay, Delegate Watts.
And now reporting on those bills in the uncontested block. The first one, HB 1553 Williams. It removes the requirement that a notice of appeal to the Court of Appeals be given to the Attorney General. The next one, HB 1568 Wiley. It has to do with the Frederick County Sheriff's Department with having concurrent jurisdiction with the City of Winchester Police Department to arrest perpetrators of all offenses committed in or upon the premises, buildings, rooms, or offices of the Joint Judicial Center or any other building located in the City of Winchester that is owned or occupied by Frederick County. The next one is HB 1642. Hayes provides, notwithstanding any other provision of law, that the recommendations or predictions provided by an artificial intelligence-based tool utilized for criminal justice purposes, as those terms are defined in the bill, shall not be the sole basis for any decision related to such criminal justice purpose. However, the results of any artificial intelligence-based tool may be used in informing a final decision, provided that any such final decision is made by a human. The next one, HB 1734, Delaney, renames the Sex Trafficking Response Coordinator and as the Human Trafficking Response Coordinator within the Department of Criminal Justice Services, and also changes related references from sex trafficking to human trafficking. The next bill on the uncontested docket is HB 1858 Arnold, and it provides that the existing statutory speedy trial protections applicable to a felony prosecution shall also apply to a misdemeanor certified to a circuit court pursuant to relevant law. And it's the recommendation of the Virginia Criminal Justice Conference. The next one, HB 74, Henson, adds retired or former law enforcement officers to the definition of public official for the purposes of prohibiting the Commonwealth from publishing a public official's personal information on the internet. The bill provides that demand by such a retired or former officer must be made before leaving the force, and that it lasts 4 years, and that upon leaving law enforcement, the individual is in fact in good standing with no pending investigations or disciplinary actions. The final one in the uncontested block, 2111, Delegate Herring, adds the executive director of the Virginia Indigent Defense Commission to the membership of the Virginia Criminal Sentencing Commission, and it is the recommendation of the Virginia Indigent Defense Commission.
All right, thank you, Chair. Do you want to move these?
I move the bills as just reported as a block.
All right, thank you. So motion properly seconded. Does any member wish to pull any of these bills out of the block? Okay, hearing none, so be prepared to vote. Annie, Ms. Johnson, you want to load that up? All right, members, please vote on the electronic voting device on the block. Clerk will close the roll. Bills report 22-0. Chair Watts.
Thank you, Mr. Chairman. The first bill, I have two bills in the contested block. The first one is HB 1661 Jones. It's moved to be reported with substitute by a vote of 7-1. As substituted, it requires the court to offer installment payments of $25 per month if the defendant requests to enter an installment agreement, except that such defendant may choose to pay a higher amount. If the defendant indicates that he's unable to pay $25 a month, the court shall assess his ability to pay using a written financial statement pursuant to current law. Lastly, the substitute provides that no court shall require payment from any defendant who was previously determined to be indigent pursuant to relevant law, except with respect to restitution. Again, the subcommittee recommended reporting with substitute, and I so move.
Mr. Chair,
Yep.
I'm not sure if I missed it. I think we need to move the substitute first.
I thought that I had. My apologies. Mr. Chairman, I moved the substitute as I just reported the substitute language in the description of the bill.
Okay, we got a motion and a second to move the substitute. All in favor say aye.
Aye.
Opposed? Okay. Chair Watts.
And now I moved the HB 1661 as substituted. Thank you.
Okay, so we got a motion and a second to report and refer to appropriations. Is that right? So does any member have any questions about what we're doing here? Voting on the bill? All right, please vote on the electronic voting device. All right. Clerk will close the roll. Bill reports and refers 14-8. Chair Watts.
Thank you, Mr. Chairman. And the other bill in this block is HB 1711, and I move the committee amendments.
Second.
A motion to approve, properly second to move the amendment. All in favor say aye.
Aye.
Opposed? All right. Chair Watts.
As amended, it creates within the Criminal Injuries Compensation Fund the Mass Violence Care Fund as a subfund for the purpose of reimbursing victims or claimants of mass violence, as defined in the bill, for unreimbursed medical expenses related to a mass violence event, again defined in the bill. The bill directs that the Virginia Workers' Compensation Commission to promulgate guidelines and criteria for payment of claims from the fund within 1 year of the effective date of the bill. The amendments clarify that a victim of mass violence means a person who has suffered physical, emotional, or psychological injury as the direct result of mass violence events. The subcommittee recommends reporting as amended and re-referring to appropriations by a vote of 5-3, and I would so move.
Okay. Motion from the chair. Can I get a second?
Second.
Motion properly second to report House Bill 1665. Does any member wish to ask a question?
Still showing the Jones bill.
Oh, I thought we were on 1665. 1711. Does anyone have a question? House Bill 1711? All right. So we got a motion and referred to appropriation. All right, please vote on your electronic voting device. It still says 1665.
1665, stop on
All right, clerk will destroy the roll.
Yeah.
There's 1711, all right. Well,
And that was as amended.
all right, clerk will close the roll. Bill reports 12 to 10 refer to appropriations. Chair Watts.
Mr. Chairman, I'm sorry, I didn't realize, I do have more, my apologies. Now also recommended to report contested, I continue with 3 additional bills. The first one is HB 1665, which is Jones, and there are no amendments. However, the bill as introduced requires the clerk of court to provide an itemized statement to any defendant convicted of a traffic infraction or violence of any criminal law of the Commonwealth or of any political subdivision thereof, found not innocent in the case of the juvenile, who is sentenced to pay a fine, restitution, forfeiture, or penalty, or assessed any other cost in the circuit court or appropriate district court. At the time such fine, restitution, forfeiture, penalty, or other costs are assessed, or within a reasonable time after assessment. The bill requires the clerk to also provide an updated statement of the outstanding balances of any fines, forfeitures, penalties, restitution, and costs, or payment history upon the request of the defendant. The bill has a delayed effective date of January 1, 2026, to accommodate this reporting procedure. The subcommittee recommends reporting 7 to 1, and I would so move.
Second.
Got a motion and properly second, House Bill 1665. Does any member have a question? All right, please vote on your electronic voting device. Members record their vote. Clerk will close the roll. Bill reports 21 to 1. Chair Watts.
Thank you. And HB 1757, Hernandez, clarifies that notwithstanding any provision to the contrary, no person found indigent or a child's parents or other persons responsible for the care of the child found indigent and who is represented by a public defender or court-appointed counsel shall have fees assessed against them for legal representation in an amount greater than the amount such person or child would have owed if the assessment took place on or before June 30th, 2024. This is the recommendation of the Virginia Indigent Defense Commission and is essentially clarifying of law. The subcommittee recommends reporting 7 to 1, and I would so move.
Second.
Got a motion and properly second. Any member have any questions about House Bill 1757 before we vote? All right, people record their votes. Clerk will close the roll. Bill reports 14 to 8. Chair Watts.
Thank you, Mr. Chairman. And now this is the final bill on our list. This is HB 1886, McClure, and the subcommittee I would move the subcommittee substitute.
Second.
Motion properly second. All in favor say aye.
Aye.
Opposed? All right, substitute is approved. Chair
Thank
Watts.
you. The substitute provides that when a district or circuit court defers proceedings against a defendant pursuant to relevant law and imposes costs upon the defendant, a court shall not enter a judgment of guilt against such defendant solely for his failure to pay such costs and other fees, but shall comply with the terms agreed to for the deferral if all other items and conditions of such agreement are satisfied. The subcommittee recommends reporting with substitute 7 to 1, and I would so move.
Second.
Got a motion properly second. Any member wish to seek recognition? All right, clerk will open the roll. Clerk will close the roll. Bill reports with substitute by a vote of 12 to 10. Chair Watts, you do have House Bill 1728. Do you want Delegate Delaney to talk? I think she does have an amendment.
Yes, Mr. Chairman, I do not have that on
Okay.
my list
Let's
as it
turn.
has been referred to full committee,
That's
so
right.
yes.
Delegate Delaney, would you like to quickly explain the bill and offer your amendment?
Thank you, Mr. Chair. So this is House Bill 1728, and this bill relaxes some of the standards to be met for prosecutors to be able to request testimony for a minor victim and witness of a crime to be admitted into evidence via two-way closed-circuit television. The bill did pass out of subcommittee, but since we have made a few amendments that have been distributed to the committee in the nature of a substitute, which I believe is before committee members, and I'll walk through what we've done.
Do we have
Oh,
Mr.
okay.
Hatcher report the
Council will
amendment?
do a better job of walking through what.
Not a better job, but
Not a better
That is
job.
good.
Yes, Mr. Chair, members of the subcommittee, this should be distributed to you. I passed the list down to both sides. If you didn't get it, there's some floating around, and it should be posted on LIS. The amendments change subsection B of this code section. The original bill had stricken the existing language from subdivision number 2 and had some other changes in subdivision 3. The substitute undoes the changes in subdivision 2 and changes subdivision 3 to read one of the factors to consider to allow CCTV, the court's finding by clear and convincing evidence based upon expert opinion testimony that the child will suffer at least moderate emotional trauma as a result of testifying in the defendant's presence and not in the courtroom generally.
all right. Delegate Delaney?
So, Mr. Chair, this has been a long work in progress to get this bill back to where it currently is. I hope that with the provisions that we have laid out in this substitute, we'll create a more trauma-informed courtroom by having more opportunities for the court to simply be petitioned to allow a child to testify via CCTV when, a still relatively high standard of trauma is met.
All right, let's deal with this, the amendment. Can I get a motion on the amendment, to adopt the amendment? Can a motion properly second? Any questions on the amendment? All in favor, say aye. Aye, opposed? All right, the bill is before us. Chair Watts, can I get you to make a motion on the bill since it originated from subcommittee? Which, by the way, this has been something that we've talked about for a few years. I will point out last session, we did get a bill out. I think it didn't make it out of appropriations but I think that this is, I want to commend Delegate Delaney for working with all stakeholders, come to a really good place, and so she should be commended. The stakeholders should be commended. I think we have a good bill before us. So with that, Delegate Kilgore, you're recognized.
Yes, I just wanted to ask a question. Thank you, Delegate Delaney, for your hard work on this issue. But can you advise me why we went from severe emotional trauma to at least moderate emotion? I'm just concerned about the finding there. Severe is a higher standard, moderate maybe a lower standard. I'm just wondering how we got from
Delegate Delaney.
Mr. Chair, yes, what we've identified is that the standard that case law has established for severe is really quite bad. We're talking about self-harm, suicidal ideation, definitely more than I think our modern understanding of what a trauma-informed courtroom should look like. It definitely exceeds that. This has been kind of a 3-year process now of trying to find how much trauma is an acceptable amount for the courtroom. I came in with this bill with a much lower standard when I first had this conversation, and would have liked to have had the opportunity for a child to have access to petition the judge at an even lower standard of trauma. But through years of kind of conversation with various stakeholders, we think that the moderate standard is a reasonable place to be. That it is not going to have the same lasting and enduring effects that severe trauma would have. It is, definitely a lower standard of trauma, which I think, is where we are now for the acceptable impact that it may have on a young person going through a very difficult situation.
Good, thank you. Any other members wish to seek recognition? Yes. Chair Watts.
Thank you, Mr. Chairman. I would therefore move House Bill 1728 as substituted
And refer to appropriations.
and refer to appropriations, of
Very
course.
good. We got a motion on the table.
Second.
Motion properly second. Any questions from members? All right, clerk will open up the roll. close the roll. Bill reports by substitute to appropriations by a vote of 19-3. Thank you, Delegate Delaney. Thank you, Chair Watts. I will turn it over to Vice Chair Simon for his bill report.
Thank you, Chairman Hope. All right, so we have an uncontested block. I guess the first thing I'd like to do is, just for the clerk's sake and ease, is we're going to remove House Bill 1721 from the uncontested block, and we have a new full committee substitute for that one, which I'll explain in just a minute.
All right, so without objection.
All right, so House Bill 1605, the first in our block of uncontested from Delegate Carlson, is changed to the Uniform Trust Code. It expands the definition of independent qualified trustee and qualified trustee to authorize additional entities to serve as an independent qualified trustee or qualified trustee of a qualified self-settled spendthrift trust. Next bill we had was House Bill 1770 from Delegate Martinez. This bill adds the term electronic to the definitions of the Uniform Trust Code. Bill also amends the definition of a trust instrument to include electronic trust agreements. House Bill 1781 from Delegate Sullivan relates to foreign protective orders and clarifies that the same criminal penalties apply for any person who violates the provisions of a foreign protective order in a case of family abuse that is accorded full faith and credit and is enforceable in the Commonwealth as if it were an order of the Commonwealth. The bill is a recommendation of the Judicial Council of Virginia. House Bill 1871 has an amendment. I move the subcommittee amendment.
Second.
Motion properly seconded. All in favor say aye. Aye. Opposed?
All right,
Delegate Simon.
and this bill has to do with transfer on death deeds and provides that an inter vivos deed is effective to revoke a recorded transfer on death deed if such inter vivos deed conveys real property to another, so the transferor is no longer the owner of at the time of the transferor's death. Under current law, an inter vivos deed is effective to revoke a transfer on death deed only if it expressly revokes all or part of the transfer on death deed. As amended in subcommittee, the bill contains an emergency clause. That was the amendment. House Bill 1912 from Delegate Reeser has to do with the.
You want to roll mine in first?
Oh, sorry. Yeah, and then we had a motion to. Sorry, I should have done that earlier. What's your bill number?
Incorporate 1644.
Yeah, we had a motion a recommendation to incorporate House Bill 1644 into House Bill 1912.
All right.
And I so move.
A motion properly second. All in favor say aye.
Aye.
Opposed? All right. Delegate Simon.
All right, and then with that creates a substitute. So I move that we adopt the committee's substitute.
Motion properly second to create a substitute. House Bill 1912. All in favor say aye. Aye. Opposed? All right. Delegate Simon.
Yeah, and so now the combined bill with the substitute increases various dollar amounts relating to wills, estates, trusts, fiduciaries, guardianships of minors, and guardianships of incapacitated persons to reflect the change to the Consumer Price Index for all urban consumers, the CPIU, as published by the Bureau of Labor Statistics of the U.S. Department of Labor, and again, it incorporates House Bill 1644. And so, Mr. Chairman, those bills were all recommended for reporting on a vote of 8-0, and I so move.
Okay. Got a motion for all those bills to be put in a block. Can I get a second? Second. Any questions? Any members wish to pull a bill from the block? All right, seeing none, clerk will open the roll for the block. Clerk will close the roll. The bills report 22-0. Chair Simon.
All right, so Mr. Chairman, returning to House Bill 1721, the Uniform Easement Relocation Act from Delegate Watts, the substitute that you have before you that was adopted by the subcommittee would have, I'll tell you what it would have done, and I'm going to tell you real quickly what our sub does. But it creates a new Uniform Easement Relocation Act, which allows the owner of real estate burdened by an easement to obtain a court order to relocate the easement if relocation does not materially impair the utility of the easement holder, the physical condition, use, or value of the benefited property. It requires the burdened property owner file a civil action, give notice to other potentially affected real property interest owners, and bear the costs of the relocation. Under current law, the owner of land that is subject to an easement may seek relocation of the easement on the serving estate upon a petition to the circuit court and notice to all parties in interest. And the petition will be granted if, after the hearing, the court finds the relocation will not result in economic damage to the party's interest. There will be no undue hardship created by the relocation, and the easement has been in existence for not less than 10 years. As amended by the substitute, the bill specifies that certain types of easements are not subject to the provision of the Act. So, again, to summarize, this will allow relocation of easements that are less than 10 years old, that won't be restricted to just ingress and egress easements, and what the bill, and we exempted, the substitute exempted certain easement holders, utility easements, railroads, and a number of folks that have large number of easements across the Commonwealth from the provisions here, so their easements won't be affected by this. What the the bill as we adopted it in subcommittee was only effective prospectively, only the easements created after July 1st, 2025. We had discussion about the subcommittee that we thought that actually probably would be better and more effective to achieve the intention of the bill if we did not have that prospective only, but allowed this to apply retroactively to all easements that weren't otherwise exempted by the bill. And so to affect that, I would like to move a substitute, a committee substitute, which would, the only difference between the committee substitute and what you all have distributed is we take out lines 14 through 23, which is a reference to the existing ingress and egress statute, since that's not going to be affected, and we take out line 249, which is the delayed, or it says that it's only effective going forward. So we take out those, I think, about 6 lines of text and make the changes in the title to reflect that we're not touching the existing law on ingress and egress.
Ms. Olwine, is that online, the reported?
Yes, Mr. Chair, it's been posted.
All right, does everyone have a chance? Does everyone know what's going on here? For the amendment? Does anyone have questions about the amendment that's being proposed? Delegate Watts, do you want to recognize?
I will just speak to the amendment. There was certainly a concern expressed by the subcommittee members about the fact that this was only prospective. And with a detailed response from the representative from Virginia on the Uniform Code Commission, a detailed response indicated that it would be perfectly appropriate under Virginia's law not to have to make it only prospective, and therefore feeling confident then that this is an appropriate amendment and reflects the subcommittee's concern on the issue.
Any questions from the members? All right, so let's go ahead and vote on the, is it a substitute?
Yeah, move adoption of the committee substitute. So we're not going to have a vote on the subcommittee, on the committee substitute.
All right, motion properly second on the committee substitute. All in favor say aye.
Aye.
Opposed? Okay, Chair Simon.
And I move adoption, or I move the House Bill 1721 report.
That's amended.
Report with substitute.
With substitute. All right. The motion before us is to amend, to approve House Bill 1721 substitute. Clerk will open the roll. Clerk will close the roll. Bill reports with substitute 22-0. Chair Simon.
All right, so we had 3 bills. This is, I call the delegate from Chesapeake docket. They were not unanimous, but they all came out on a vote of 17 to the delegate from Chesapeake, or 7. So starting with House Bill 1690 from Delegate Converse Fowler, this bill, as amended by the there's a substitute here. I move adoption of the subcommittee substitute.
Motion properly second. All in favor say aye. Aye. Opposed? All right, substitutes before us.
And as amended by the substitute, the bill provides that a report showing all matters that affect the current ownership, existing liens, encumbrances, and other matters affecting title as of the date of the title report, as defined in the bill, shall be provided by the condemnor to a landowner in a condemnation action. Under current law, there were some interpretations that said you had to have every document that had ever been recorded for the last 60 years provided.
Okay.
And the subcommittee recommended reporting by a vote of 7-1, and I so move.
I got a motion. Second. Got a properly second. Delegate Lethwich, you seek recognition.
Thank you, Mr. Chairman. As Chair Simons indicated, I was a sole no vote. I've done a little bit of research on this, and I'm perfectly comfortable with the bill, and will be changing my vote to a yes.
Kumbaya. That makes me so happy. So happy right now. All right, so we got a motion and properly second. Any other member wish to seek recognition? Okay, Bill. Clerk will open the roll. Clerk will close the roll. Bill reports 21-1.
Too bad. I'm sorry.
Close the roll. Chair Simon.
House Bill 1730. Is there a motion on this?
Is there a motion? Delegate Ballard, did you want to be recognized on this?
I would, Mr. Chair. Thank you. So on 1730 in the civil sub, I did vote in favor of this, but I also expressed some concern, my concern that as drafted, it's a pretty broad bill. And I know that relevant stakeholders have approached the patron as well as members of the committee about the language. I do believe that a legislative fix is necessary based on what the Supreme Court did especially in my mind, where they're taking away this issue from the province of the jury. That said, I still think the bill is a little too broad as written. I would like to see the stakeholders get together and try to work on the language so that it is more reasonable. So with that, Mr. Chair, I ask that we take this bill by for the day.
Bye for the day. I agree, Delegate Ballard, there's been some decisions out of the Supreme Court that have been concerning, but it does make me happy that I've heard that there's some talk around this and trying to get to a better place, so this bill is progressing in the right direction, and with Delegate Delaney's assent, I agree the bill go by today. So without objection, the bill goes by for the day. Delegate Simon, rather.
All right, so, Mr. Chairman, the last bill on my report is House Bill 1775 from Delegate Sullivan, having to do with divorce, adultery, and it specifies that divorce may be decreed on the grounds of adultery, provided that such adultery occurred prior to the final separation of the parties. The bill further allows for divorce from bed and board to be decreed on the application of either party upon the parties living separate and apart. Under current law, a divorce from bed and board may only be decreed for cruelty, reasonable apprehension of bodily harm, willful desertion, or abandonment. This bill specifies that no waiting period is required for the filing of such a divorce, but the decree of such a divorce may only be decreed pursuant to certain requirements otherwise specified in the law. The committee recommended reporting on a vote of 7-1, and I so move.
Got a motion to report 7-1. Can I get a second? Second, properly second. Any members have questions? Seek recognition? Okay. Clerk will open the roll. All members have voted. Clerk will close the roll. Bill reports 16-6. Delegate Simon, is that your
Mr. Chairman, that concludes my report for this week.
All right. Then, Delegate Early.
Mr. Chairman, I'm sorry.
Excuse me.
Having voted on the prevailing side of HB 1757, I would ask so that we could reconsider that vote so that a member may change the vote.
Can you repeat that, Delegate Early? House Bill
1757.
1757, Hernandez, that's the criminal subcommittee. Bill, can we put that back up? House Bill 1757. I heard a second, didn't I? Second. Okay. All in favor, say aye.
Aye.
You ready? So bring it back up for a vote? 1757.
And what's the motion?
The motion is, do you restate the motion, Delegate Early?
Well, who has to reconsider?
We vote on the prevailing side.
Yeah, having voted on the prevailing side, I make a motion that we reconsider the vote of House Bill 1757.
We did that, now we got to vote to report again.
Okay, clerk will open the roll. All members have voted. Clerk will close the roll. Bill reports 15-7. Okay, I believe that completes the business of the committee. The criminal subcommittee will convene here just as soon as we can switch things out. The committee stands adjourned.